for Heffron.
Mr Acting Speaker, I make a contribution to the Evidence Amendment Tendency and Coincidence Bill 2020, and what I say should be seen to be endorsing the remarks made by the member for Liverpool. The time allotted to me does not allow me to go in detail in relation to the provisions of the bill. However, I want to make some observations from almost a lifetime in the criminal justice system, where I have appeared for people charged with offences of this nature and have prosecuted them. Ever since the enactment of the Evidence Act, which was supposed to be a uniform evidence law, but initially was only adopted by New South Wales and the ACT, and still hasn't been adopted uniformly across the country. The provisions of Section 97 and 98 and Section 101 of the Act that relates to tendency and coincidence have caused huge difficulties in all areas of the criminal law. In fact, until the High Court determined Bauer in 2018, it's fair to say that nobody really knew what they actually meant. Prior to the enactment of the Evidence Act, everybody knew what similar fact evidence was. If uncharged acts were strikingly similar, you knew it when you saw it. But adding the level of complexity and the wording used in Section 97 and 98, and then applying in criminal matters the test in Section 101, the courts have struggled to apply them. Now, most of the time, the use of tendency and coincidence evidence applied to sex offences, particularly child sex offences. It was those offences whereby evidence of uncharged acts was to be led by the Crown in an effort to show that the charged acts of an accused were not acts in isolation. Now, it makes common sense, doesn't it, that if a child is able to give evidence of certain acts occurring to them, and there are evidence of other similar acts occurring, then that evidence should be admitted so that the evidence can be considered, and the word is in context, so that the allegations aren't allegations in isolation, that sexual interest can be proved. So that makes common sense. The problem is that the words of the statute made it extremely difficult for anyone to apply. Now, the Royal Commission, chaired by Justice Peter McClellan, did outstanding work. Now, I do want to remind the House that the Royal Commission was in relation to institutional abuse. And I would hazard to guess, anecdotally, from my experience in the criminal justice system, that institutional abuse is only is a minority area of the abuse that is occurring to children. So much of it permeates society and always has permeated society. But in terms of the breadth and difficulty of that evidence, there's no better person than Justice McClellan, who himself at the bar was an expert at being able to distill expert evidence. There was no better person to be responsible for preparing the report. In 2017, they made recommendations in respect of tendency and coincidence evidence, and from their investigation, they attributed to the inability of the Crown to lead evidence as tendency and coincidence was responsible for the acquittal of guilty offenders. If that be the view of Justice McClellan, I respect it and I value it. Trial judges have told me anecdotally, since the McClellan report, there has been, without a change of the law, an increase in the number of convictions for these offences, uncorroborated historical offences, and judges speculate that it may well be that the community, through their representatives, have greater knowledge of these offences than they did have prior to the Royal Commission and the associated publicity associated with the Royal Commission. Now, since the Royal Commission's report and recommendation, the Council of Attorney-Generals have spent quite a considerable period of time in an effort to adopt a uniform approach to tendency and coincidence, and that uniform approach is contained in this bill proposed by the Attorney. The only observation I wish to make is, in respect of it, is this, that since the Royal Commission's recommendation, the High Court determined the Queen and Bauer, reported a 2018 High Court reports at 40, where it gave a unanimous judgment on three very important issues. Firstly, when is tendency evidence admissible in sexual assault cases where there is a single complainant? 2, how should a judge balance the different statutory considerations on when to allow pre-recorded evidence from a previous trial? And 3, what can a judge consider when deciding whether previous representation evidence is fresh in the memory? Now, the High Court acknowledged that their previous judgments on tendency evidence had caused difficulty, and they must provide a clear test for trial judges. In fact, Bauer really holds the distinction of being a unanimous High Court judgment on tendency evidence, unlike a number of their previous decisions. So they had spoken with one voice to provide guidance to lawyers and trial judges and appellate courts on how to deal with single complainant evidence cases, such that often involve a few witnesses, and so surrounding circumstances can be significant for a jury. Now, following their determination, work commenced by the Attorneys General concludes afterwards, and some changes are proposed in this bill. I don't oppose the changes because, despite the High Court's unanimous judgment to clarify wording of section 97, 98 and section 101, to this day I'm still not sure what it means. So clarifying, for example, section 101, which is to apply to all criminal cases, by removing these words, the probative value of the evidence substantially outweighs any prejudicial effect it may have on the defendant, removing that from 101 and replacing it with the probative value of the evidence outweighs the danger of unfair prejudice to the defendant, makes a lot more sense. I mean, I know what that means, and so will lawyers and so will judges. The problem is that as a member for Liverpool observed, it will just open up another area of jurisprudence. It will provide another argument for lawyers to appeal decisions of the court when the issues themselves seem to have been settled by Bauer and the High Court. So, you know, I just have that caveat in relation to the amendments, although I understand the basis, the basis of the amendments. The other observation I want to make is just give the House the benefit of my advice, both in prosecuting and defending hundreds of these cases. And might I say, it matters not whether you prosecute them, defend them, or whether you're a judge presiding on them. Nobody likes doing these sorts of cases. However, you know, the situation in relation to it is this. What the Crown wants to go before the jury is evidence of uncharged acts that make it more likely or not that an accused has acted in the way in which the Crown charges. Now, that's the evidence that the Crown wishes to lead. Mr. Acting Speaker, might have an extension of time.
Member Heffron's requesting an extension of time. Is extension granted? Extension's granted.
The question is what are the circumstances of that evidence being for that evidence to be admissible, and the bill tries to make it clear. But what the House needs to appreciate is simply this. If you were to look at the directions that a jury needs to be given when uncharged acts are to be utilised as tendency evidence, as distinct to context evidence, I venture to suggest that a jury would have no idea what the judge is talking about. And take it from me, who's somebody who has seen it hundreds of times, you can see the jury's eyes glaze over as the judge is giving legal directions to a jury that a judge is required to give. The complexity of the law and the complexity of the wording makes it extremely difficult for even a lawyer to understand, let alone a jury. And as I just pointed out earlier, even the High Court have struggled to get it right until Bauer. It's many years of appellate courts throughout this country and the High Court in majority-minority judgments trying to give guidance to trial courts. So that when a jury is confused in terms of the legal direction, there is a fear that maybe the complexity of the directions doesn't allow the jury as a trier of fact to necessarily understand what they do. Now, I raised that recently with some judges who did remind me that not only since the Royal Commission have there been more convictions without a change of the law, but the juries have been relatively discreet in their verdicts. So there might well be, say, 5 counts charged in respect of one complainant, of which the jury have convicted of 3 and acquitted of 2. So despite the complexity of the directions that they're bound to give the juries have been shown to be discreet, and that's anecdotal material I provide the House. I just tell the House this, is that, of course, this change of the law does not necessarily change the law that relates to all uncharged acts. So there all are uncharged acts that don't fit within tendency and coincidence that would still be led as context. Or it may well be, as some prosecutors, including me at times, have preferred not to rely on tendency, but have led the evidence anyway as context, because all I wanted to do was have the evidence of uncharged acts before the jury so that the jury could know about them and have the judge's directions being as simple as possible at the end of the day to judge the evidence. I suppose fortunately in all those cases the jury have convicted the accused, but again, to provide a fair trial, it really is essential that the jury understand precisely what the directions are. So what I say in respect of this bill, particularly those parts that amend section 97 and 98, and add section 97A, they operate as a clarification of the law. They are still complex. They are not designed to ensure an unfair trial of an accused. They are designed to ensure that uncharged acts can be more simply admitted as tendency and coincidence, and to repair an area of the law that every court, every appellate court, including the High Court, has struggled since the enactment of the Evidence Act.
I thank the member for Heffron.